So, good day everyone. Good day, sir. I am Hernandez from PCBet 01402A. And for today, I will be discussing about the Section 2 property rights of a partners. So, Section 2 property rights of a partners covers the Article 1810 property rights of a partner. The first is his right in specific partnership property, his interest in the partnership, and his right to participate in the management. So before we further discuss these three rights, we will be talking about first the property and the capital. So property is different from the capital contributed in the partnership because property, these are the assets that are variable, meaning value may change as the market value changes. While these assets or this property, it includes here the capital itself, meaning capital its value will always be constant, consists of money, property, or industry in accordance to Article 1767. So, the first right of the partner is his right in specific partnership property. So, it contemplates tangible property, meaning these are the property that is, for example, vehicles or business equipment, furniture, and etc. And this property, it belongs to the partnership itself. So Article 1811, a partner is co-owner with his partners of a specific partnership property. So let's say for example, me and CJ organize a general partnership. So CJ contributed a property like a truck. Okay, she contributed a truck. While on the other hand, I contributed a warehouse. So therefore, because we are partners already, the property that she contributed is I am already a co-owner with that. So therefore, since we are a partners, the property that she contributed is already owned by me because we are partners. That same goes with the property that I contributed in the partnership. She is already a co-owner of that as we are a partners. Okay? So, the partners have no actual interest in the specific partnership property as until the partnership dissolve. Okay? So as a result of that, there are some incidents. So the first incident is a right of possession. So each partner has an equal rights with these co-partners to possess a specific partnership property for partnership purposes only. So therefore, the partner has no rights to use or possess the specific partnership without the consent of other partners. And if ever that the partner uses that specific partnership for his own actual profit, then that profit must be accounted to his or her co-partners. So, number two, a partner's right in specific partnership property is not assignable, meaning it is not transferable rather. Why? Because the individual's partners have no specific interest in the specific partnership property which belongs to the partnership. Again, once that a property is already contributed to the partnership business, meaning it is now owned or belong to the partnership. So let's say for example, if CJ contributed to our partnership a truck and I contributed a warehouse, then meaning that truck and warehouse is already owned to the partnership and we cannot longer assign our individual interests as because the property is already owned to the partnership. Again, the partnership has a juridical personality. Okay? So, it is impossible for the partners to determine the extent of their beneficial interest until after the liquidation. So, liquidation meaning it is a winding up or the company's assets are liquidated and the company are closed. This also serve as a protection to the partner's right and also to the partnership creditor to have the specific partnership property if ever that a partnership have any liability to them. And also it prevents the outsider to interfere with the partnership example. Okay? So, take note that all partners may collectively make an assignment of their entire interest in any specific partnership property but it has to be all of them. Okay? Again, it has to be all of them. They can make an assignment of their entire individual interest in any specific partnership, but it has to be all of them. Okay? So the third incident is a partner's right and specific partnership property is not subject to attachment or execution. A specific partnership property is not subject to attachment or execution against an individual partner because the property does not belong to the partner, but it belongs to the partnership itself. It is owned by the partnership. However, if a claim is brought against the partnership, then property can be subject to attachment or execution. So let's say for example, the general partnership that CJ and I organized started its operating business. And then eventually, nagkaroon kami ng liability. Okay, nagkaroon ng liability ang partnership. Then that's a time creditor can brought a claim against the partnership, then the property can be subject to attachment or execution because again, the liability belongs to the partnership and that's the time that the specific partnership property of the partnership can be subject to attachment or execution. Okay, again, the partnership has a separate juridical personality. Kung ano yung liability ng individual partner, ayun lang yung liability niya. And the specific partnership property is not subject to its attachment or execution. But if ever that the liability of partnership arises, then that's the time the specific partnership property is subject to the attachment or execution. Kung ano yung sa partnership lang yun. Pero kung ano yung individual's interest ng partner, ay sa kanila lang yun. Okay? So, a partner's right in specific partnership is not subject to legal support. Why? Because the property belongs to the partnership. Again, the partnership has a juridical personality. It is separate and distinct from the partners itself. And it is only the partner's interest in the partnership may be not subject to legal support. So the fifth incident is the partner's interest is not a debt due from the partnership. So creditors of single individual partners may go after the partner's interest, but he or she cannot go after the partner's specific interest. So let's say for example, CJ and I are partners in a general partnership. We organize a general partnership. And then eventually, I have a liability from someone. Okay? And then that someone, that creditor, may go after my individual's interest. But he cannot go after my specific partnership property. Okay? Why? Because it has a separate personality. What belongs to the partnership does not necessarily belong to any individual partners. What can they only have is the beneficial interest. So this beneficial interest, they have the right to live in the property. The partners, okay, the partners have the right to live in the property. They have the right to the share of the rental income, okay, if ever that the partnership business is a leasing business, and a right of a share of the proceeds of sale if ever na binenta nila yung specific partnership property nila. Okay? So, we will be proceeding to here. Okay? So, before we proceed to the second right of a partners, let's now discuss first the specific partnership property and partners' interest. For you guys to be able to understand more yung mga susunod na rights, I will be discussing about you the difference between the specific partnership property and the partner's interest. So when we say specific partnership property, it is the partnership's property. Okay? The property, it is the property that was contributed by the partners to the partnership business. So if CJ and I are partners, she contributed the truck and I contributed a warehouse, that's the specific partnership property. The truck and the warehouse are the partnership property. While on the other hand, the partner's interest, it is a property or an asset owned by the individual property. So if CJ owned a truck and she contributed it to the partnership and I contributed also the warehouse, then we have our own asset or property that was not contributed to the partnership. It is our own personal property. Let's say, for example, I owned a land in Bataan, let's say 100 hectares or etc. While CJ, on the other hand, she owned a building. Okay, she owned a building. The building and the land the building that CJ owned and the land that I owned, that is our partner's interest. It is our personal property. It is our personal asset. And this right, the first right, his right to specific partnership property, it talks about the partnership has a separate juridical personality. Kung mapapansin nyo, all throughout, the partnership doesn't have any involvement to the partner's interest, because what belongs to the partnership, it belongs to the partnership, and what belongs to the individual's partners belongs to the individual partners, including all their transactions and etc. Okay, so the next right of a partner is a partner's interest in the partnership. So according to Article 1812, a partner's interest in the partnership is his share of the profits and surplus. So a partner's share of the surplus pertains to the excess of returns over expenditures. So basically, ito yung kita ng partnership, and ito yung magiging share ng isang partner after nakumita ng isang partnership over a transaction or a series of transactions. While on the other hand, a partner's share of the surplus, it pertains to the excess of receipts over disbursement, meaning these are the funds that still remain in the partnership after all the liabilities and debts have been paid to the creditors and also the equities have been adjusted. So, since the interest of a partner is a personal property, again, a partner's interest is a personal property, a partner may assign his whole interest, the surplus and the profit, in the partnership, and this will not necessarily result in the solution. Why? Because it is the partner's personal property and not the property of partnership. So, who will be the person who will receive the partner's whole interest? So, it is called the assignee. So, the question, if this assignee already will be receiving the partner's interest, okay, the partner's interest, does it make them to be a partners also? So, to answer that question, it is not, okay? The assignee rather does not become a partner, and they cannot interfere in the management. They cannot also acquire information in the accounting, and also they cannot inspect the partnership book. However, these assignee have a certain rights. So, the first right is he or she, okay, has the rights to receive profits in accordance with this contract, which the assigning partners would have otherwise been entitled to. He or she can avail himself or herself the usual remedies provided by law in the event of fraud in the management. So, what are these usual remedies? So, it is called the damages. Damages, it is the money paid from the other party to the other party. So, what are these damages? It is the compensatory damages, consequential damages, and etc. So the third right is he or she has the right to receive his assigner's interest in case of dissolution, as well as to require an account of partnership affairs in case the partnership is dissolved. This account of partnership affairs, it will cover the period from the date only of the last account agreed to by all the parties. A partner's right in a specific partnership property is not subject to execution or attachment against him as an individual partner, but a partner's interest in the partnership as a rule here can be assigned, can be attached, and can be subject to legal support. And a creditor may subject the partner's individual interest in the partnership to attachment. Why? Because it is a partner's individual interest, the surplus and the profit. So, a surplus share after the firm's debts are paid and equities to the partners are adjusted will be the creditor may go after and not the specific partnership property. So, how the attachment will be done? So, the attachment will be done through the charging order. So, this charging order will be further discussed with the next reporter. Okay? So, the next right of a partner is the right to participate in the management. So, every partner is an agent in the partnership. So, agent meaning a person who has been legally empowered to act on behalf of another person or an entity. Therefore, a partner can be a person who is legally empowered to act on behalf of his co-partner and also to the partnership itself. And it will always be for the purpose of partnership business. So, here in the third right, the partners have the right to participate in the management. So, in managing a partnership, there's a certain rules for the partners. So, what are these rules? So, rules in management. So, number one is when the manner of managing the partnership has not been agreed upon, then all of the partners shall be considered as the agent of the partnership. Therefore, whatever they may do alone shall bind the partnership. So here, the partnership doesn't have or does not appointed yet rather a managing partner. The managing partner, this is the partner that execute administratively in the partnership. They make decisions for the partnership. So here in the first rule, if the partnership doesn't have any managing partner yet, then all of the partners shall be considered as the agent of the partnership, and whatever decision or execution they may do alone, it shall bind the partnership itself. So what if in the partnership there's already an agreement, the partnership already appointed a managing partner? So what are the rules? So here the rules are, first, when only partner is appointed as a managing partner, that managing partner may execute all acts of administration despite the opposition of his partner, except that if that managing partner acts in bad faith, okay, he did something wrong. So in this rule, there are two sub-scenarios. We will be having this two sub-scenarios. So the first sub-scenario is if the managing partner was appointed manager in the articles, then his power is irrevocable without just or lawful cause. Meaning, that managing partner was appointed manager in the contracts of partnership or in the articles of the partnership. Therefore, his power is irrevocable, meaning he cannot be removed, okay, unless that he did something wrong or he acts in bad faith. So if he acts in bad faith, to remove that managing partner, the vote of the partners representing the controlling interest is necessary. So meaning this partner represent the controlling interest. His decision will matter whether that managing partner who acts in bad faith will whether or not stay in the partnership. So, question, what if you just want to remove the managing partner and he did not do any lawful cause? Can he be removed? So, to answer this question, yes. That managing partner, even though he did not do anything wrong, okay, he did not do any lawful cause, he can be removed as long as the vote of the partners is unanimous. Why? Bakit kailangan ma-remove siya even though he did not do any lawful cause? It's because it represents the change of feel of the parties. So therefore, they must give all their consents in order for the articles of the partnership or the contract of the partnership modify. Okay? The next sub-scenario is what if the appointment of the managing partner was granted after the creation of the partnership. So, this managing partner that was granted after the creation of the partnership, he or she may be removed by the partners having controlling interest or such composition prescribed in the articles of partnership for any cause. Why? It is because he was granted by that position as a managing partner after, after the creation of the partnership. So, therefore, his power is just a mere delegation power, meaning um, the position that was given to him or her was given after the creation of the partnership, and therefore, and this condition does not included to modify to a contract of a partnership. So compensation. So does the that managing partner, that appointed managing partner after the creation of the partnership is entitled or not with the compensation? So the answer for that is that managing partner is not entitled to any compensation, but the parties may expressly grant it to him. So the second rule of a rules in management is two or more persons have been entrusted with management and without specification of their respective duties and no stipulation that one of them shall not act without the consent of all the others. So let's say for example, me and Elijah was entrusted or have been entrusted with the management of our partnership. But it doesn't specify what are our respective duties, and we need to ask, ask for the consent of all the others before we act about something. So each one of those managing partner may separately execute all the act of administration, but if any of them oppose with the act of the others, then it will be solved by the majority decision. But if a tie, the decision of managing partners owing the controlling interest shall prevail. So, take note, this rule govern only the relationship among the partners themselves and not the partnership itself, and a breach of contract may result to any cause of action against the partner who is at fault. So question, what if it cannot be resolved to tie? There is still a deadlock. It cannot be resolved to it cannot be resolved to a tie. So what are the rules? So the partners who vote against the contract shall prevail as it is considered entered into without authority. So the third rule of management, if it is stipulated that none of the managing partners shall act without the consent of other parties, meaning the managing partners, in order for them to perform an act, they need to ask for the consent of the other parties. And all parties must consent for the acts to be valid, and they cannot argue that they cannot give their vote because for some various reason, like they are absent, they are in a vacation, they are doing this, they are doing that. And the only time that they can say that kind of excuses or reasons if there is an immediate danger of grave or irreparable injury to the partnership. And this requirement of the previous approval is only applies to the execution of formal contracts and not or does not apply to the routine transaction or a daily transaction. So take note on immovable property. None of the parties may, without the consent of others, make any important alterations in the immovable property of a partnership, even if it is useful to the partnership. These important alterations, meaning these are the useful expenses. When it comes to the necessary expenses, it can still be done. So, the reason why there is this a rule on immovable property is the heart of the partnership. So if ever that someone make any important alteration without the consent of the others, then it might affect the right of the other parties. And if ever that there's a refusal in the manifestation of the partnership interest, then the best remedy that can be recommended to them is they can just ask for the court's advice, or they can just go to the court to solve this kind of problem for them. So I have here an example. It's like an application for you guys to fully understand what the third partner's right actually mean. So Elijah, Hillary, Nicole, And Sheila, me, yours truly, we organized a general partnership wherein Elijah and Hillary are the industrial partners. Nicole contributed a 10,000 pesos and me contributed a 30,000 pesos. So Elijah and Hillary was appointed as a managing partners but without the specification of their respective duties. So later on, they appointed Cloyd as an accountant of the partnership. But after 1 year, Elijah wanted to dismiss Cloyd for some reason. Let's say, hindi niya nagustuhan yung performance ni Cloyd. So, he wanted to dismiss it. Apparently, Hillary opposed dun sa decision ni Elijah. She said that he doesn't want to dismiss Cloyd as he is an effective accountant for the partnership. So, according to the rule, the decision will be on the managing partner. But in this case, Elijah and Hillary are only two. So, therefore, there is no majority decision. Clearly, there is a tie because they are opposing each other. What are they going to do? So, the decision will be on the controlling interest. To Sheila, me, nasa akin ang decision because I have the highest contribution to the partnership. So, therefore, I have the controlling interest. So, my decision will matter whether or not Cloyd will stay on the partnership as an accountant or not. So, example number 2. So, what if there is no managing partner? Elijah and Hillary is no longer a managing partner. What will happen? Then, that's the time the vote of the majority will prevail. And in case of tie, then the vote of the controlling interest will prevail. So, that would be all, and thank you for listening. I hope that everyone understand my topic, and have a nice day.